Don't look like a flight risk. Hello, this is Michael Lowe. Today we're going to talk about federal investigations. Before we get started, I want you to know that this is not meant to be legal advice in your specific case. The only legal advice you should take is from the attorney you hired. Federal cases are a little more complicated than state cases. They often involve many documents, many witnesses, and many defendants in conspiracy cases. Because they're so complicated, federal agents like to start at the bottom and then work their way up. Throughout this process, certain members of the conspiracy may discover that they're being investigated by federal agents. And one of three things can happen at this point. Those folks who find out that they're being investigated can contact an attorney, and their attorney can contact the U.S. attorney, or the folks who find out they're being investigated can do absolutely nothing and just hope for the best. And the third thing that can happen is the folks that find out that they're being investigated can begin to obstruct the investigation. Today, I'm going to go over my top 10 do's and don'ts for folks who think they're being investigated by a federal agent. So let's get started. Before I tell you my first recommendation, you should know what happens when you get arrested on a federal case. The first thing that's going to happen is the US Marshal is going to bring you to the federal courthouse and you're going to meet the federal magistrate. The federal magistrate is going to hand you the indictment or complaint, and then the federal magistrate is going to ask the US government if they're moving to detain you. If the government is moving to detain you, then the US magistrate will reschedule the hearing for another day later that week, and you will have something called a detention hearing. Before the detention hearing, the magistrate will receive a report from United States Probation, and that report will make a recommendation concerning whether or not the person who's been arrested is a flight risk or a threat to the community. And the probation officer makes an investigation of their own to make these determinations. And one of the things that they do is they actually interview the defendant. So my first recommendation is don't look like a flight risk. Don't move if you find out you are being investigated on a federal case. Don't move in with your girlfriend, and don't start traveling around the United States or try to leave the country. You should also not possess a weapon. Don't possess a weapon in your house. Don't possess a weapon in your car. Don't possess a weapon in your boat or your storage unit. And finally, you should cooperate with the United States probation officer when they interview you. They will ask you questions about where you live and where you've been living. And they will also ask you where you intend to be living should you be released. Make sure you give clear, consistent answers to the United States probation officer so that they can make a favorable report about where you're living. If the United States probation officer doesn't know where you've been living or can't determine where you will be living when you're released, then you can be sure that the report that they give to the federal magistrate will not be in your favor, and that will weigh heavily at a detention hearing against you. Number two is a simple one. Don't change your name. Don't start renting properties or signing leases in other people's names. And also, don't try to recharacterize the ownership of assets that you have. In other words, don't change the name of your property as well. If you do this, it's going to make you look bad at a detention hearing and potentially look bad at a trial. So keep everything status quo. Number three, find out who's investigating you or who's looking for you. Sometimes federal agents will make direct contact with a target of an investigation. When this happens, it's very important to find out the name and identity of the federal agent who's contacting you. With this information, you can politely decline to answer questions and then contact an attorney. When this happens in cases that I handle, I will oftentimes reach out to the federal prosecutor assigned to the case, and I will send them a letter. And the letter looks something like this. You'll notice from the letter that I volunteer to surrender my client to federal agents should a warrant become active in their case. And this may seem like it's some sort of confession or something like that, but it's not. It doesn't hurt you in any way. And the reason why I do this is because should there become an active warrant, and should the federal prosecutor choose to not let me know about that and try to arrest my client by surprise, and then file a motion to detain my client later on, I can use that letter to show the federal magistrate at the detention hearing that my client was always cooperative and always willing to turn themselves in. In other words, the letter can be used to prove that my client is not a flight risk. So make sure you find out who is looking for you and pass that information along to an attorney so that they can help to protect you. Number 4, know what's on your phone. In the previous example I gave, the federal prosecutor intentionally arrested my client by surprise, and she did this because she wanted to get a search warrant for my client's phone. In that case, she was unable to find any incriminating evidence on my client's phone because I had told my client that this was a possibility. And I also advised my client to make sure that he wasn't involved in any illegal activities while he's being investigated. So if you think you're under investigation, you should make sure you know what is on your phone. Number 5, if you know somebody who has been contacted by federal agents, someone who you've done business with or worked with in the past, or if you find out that that person's been arrested and charged in a federal case, you should not speak to them. Sometimes federal agents want the target of their investigation to find out that they're being investigated. And you might ask yourself, well, why would they want them to find out? Well, the answer is they want to see if the target will attempt to obstruct the investigation. And this may seem like it's something the federal agent may not want to happen, but oftentimes the federal agents have a very good case against the target, and they just want to see how the target's going to respond to the knowledge that they're being investigated. And in the event that they do obstruct the investigation or attempt to obstruct the investigation, you can be sure the federal agent's going to be watching that and is going to use that against the target of the investigation at their detention hearing or at their trial or at their sentencing. So it's very important for you to not speak to other folks who have been contacted by federal agent or who have been charged by federal agents. Number 6 is similar to number 5. If you've been contacted by federal agents or if you've been arrested in a federal case, don't tell anybody. It is common for people who are charged or arrested on a federal case to immediately want to go to trial in their case to be vindicated. However, you may want to consult with an attorney and review the evidence and then make a decision about what you want to do with your case. There are times when a person who's charged in a federal case or under investigation in a federal case may want to cooperate in their case. But if they've told everybody that they've been investigated or are being investigated or have been charged in a federal case, then it's going to make it nearly impossible for them to cooperate. So don't tell anybody about your case so that you at least have the option of cooperating if you want to cooperate. And if you don't want to cooperate, that's fine, but at least you'll have that option. Number 7, if federal agents come to your home or your place of business and want to interview you, or if you get arrested and they want to interview you after you've been arrested, politely decline to answer questions and tell them that you'd like to talk to an attorney. You're not going to offend them because it's something that they've heard many, many times before. It's also not something that can ever be used against you in court. Later on, when you have a lawyer, I can contact the U.S. Attorney's Office and get a written immunity agreement so that you can give truthful statements to the government should it be in your best interest. But the bottom line is, don't give any statements on your own without a lawyer. Number 8 is similar to number 7. Federal agents will often bring up certain topics with you in an attempt to see how you will respond. And it's important to respond with a surprise and ask for an attorney. It is a very common tactic for federal agents to ask questions like, you know why we're asking questions about this, don't you? And it's important to respond with a surprised look and say, no, I don't know, and ask to speak to an attorney. Number 9, don't answer any questions, even if the questions seem innocuous or inconsequential. This is common when a search warrant is being executed. Sometimes when a search warrant's being executed at a residence, the federal agents are looking for digital evidence. And when they're looking for digital evidence, They may ask you questions about email addresses or logins or passwords. They may ask you questions about who uses this computer or who pays the internet service at this location. It's very important to not answer even the most inconsequential questions when a search warrant is being run. And number 10, the most important rule, timely hire an attorney and make sure you tell your attorney the whole truth. It's very important to hire a lawyer early so that the lawyer can prepare for worst case scenarios. If you get arrested in a federal case and the government moves to detain you, your lawyer will have a very short period of time to prepare for the detention hearing or prepare for a probable cause hearing if you had just hired your lawyer right after you got arrested. But if you hired your lawyer long before the arrest, then your lawyer could begin to prepare for the worst case scenario of a detention hearing or a probable cause hearing. And your lawyer would be much more effective at that hearing at getting you released. And a corollary of this rule is to be honest with your lawyer. And this is particularly important in federal cases, because if you're not honest with your lawyer or you don't tell your lawyer everything you know about the case, then before a detention hearing, your lawyer may not have as much information as the government. It is very uncommon for a defendant to receive significant discovery from the government prior to a probable cause or detention hearing. This can cause a great imbalance in the preparedness for the defense for those hearings. And it can make that situation much worse if you're not honest with your attorney or you don't disclose everything to your attorney. In my experience, I've found that some folks think that if they shade things in the light most favorable to them when they first meet with their lawyer, that it's going to make their case turn out better. But it's actually the opposite. If you give your lawyer bad information or don't tell your lawyer important information, then it's kind of like garbage in, garbage out. Your lawyer will then take that bad information and make bad decisions on your behalf and give you bad recommendations. So in order to get the best from your lawyer, it's important to be totally honest. Your lawyer cannot tell anybody about anything that you've said, and your lawyer is not there to judge you like somebody at church would. Your lawyer is there to simply objectively evaluate the evidence and put you in the best position possible to win. I've had many clients over the years who came to meet with me for the first time, and they were totally honest and totally disclosed everything that they did. And then I went on to get their case dismissed, or to get a grand jury no bill, or to get a not guilty. And nobody ever found out about the things that they told me. So it's very important for you to be straightforward and honest with your lawyer. Thank you very much.